Okay, so we've been discussing how Asians have been challenging their exclusion from naturalization. And let's remember there are laws that work in this regard that function to maintain that exclusion. Of course, those are immigration laws, but also naturalization laws. And as we notice, they work in tandem. They are parallel to each other in that regard. Now, we also discussed some naturalization laws like the aliens ineligible for citizenship, which was, of course, included in the 1882 Chinese Exclusion Act. But we also talked about the Wong Kim R case. And this case is important because the Supreme Court recognized that second-generation Asians should indeed enjoy birthright citizenship rights. Okay, so fast forward to the 1920s, and should be noted, first of all, that the 1920s was a high point of anti-immigration, high point of nativism in our country. And this is specifically emanating from the Anglo race, the Anglo-Saxon race, if you recall, meaning English descendants. And they were very concerned, very anxious. In fact, they were wringing their hands in agony with all these different European groups from Southern Europe and Eastern Europe. And they felt like the ethno-racial homogeneity of the country in terms of, the white race was being diluted by all these other European races. So they wanted to preserve that, what I called racial homogeneity. And therefore, you see these laws being applied, like immigration laws and naturalization laws. But this is a challenge because, whiteness was at this period, that is to say the late 1800s into the 1900s, early 1900s, was being challenged by various persons who were pursuing citizenship and naturalization. Okay, so here is an Asian person, however, in the 1920s during this high point of nativism, and his name is Takao Ozawa. And here's some background on him. Well, Ozawa described himself as a paragon of assimilation. He had lived in the United States for 28 years at this time. I mean, he graduated from, American colleges, UC Berkeley, Berkeley College, as it was called back then. He actually severed all his ties, to Japan, like cultural, emotional, what have you. He chose to speak English in favor of Japanese, and indeed his children were schooled in American schools. He didn't teach them Japanese. They only spoke English. So he was self-described as a, quote, true American. And because of this, and because of the fact that according to the literal interpretation of white skin, if you look at his picture, he indeed looks white from outward appearances. So, basically, he's going to press his claim towards naturalization rights by claiming he is white. And let's remember, what's still operating at this time was the 1790 Naturalization Act, which defined, defined eligibility, as persons who were white only. Okay, so he filed for citizenship in 1914, and he lost that at the lower courts. So he pursued his case doggedly for the next few years until it reached the Supreme Court. And let me remind you that Ozawa is claiming his whiteness based on his literal skin color. Okay, literalism here. Now, by the way, when this reached the Supreme Court, the case caught the attention of the entire nation, and especially the Japanese in America, because, again, all this discussion of who is white, who is Caucasian, is mostly emanating from European groups, right? Italians and Eastern Europeans. But here's a Japanese person who's claiming he's white, and again, he's basing his argument on common sense or common knowledge. That's what we called it when you base it on the actual color of your skin, right? Okay, so he claimed the skin is white, therefore he was interpreting that, quote, white person quite literally. And when this case reached the Supreme Court, the justices denied Ozawa. And let's read what one justice wrote in his opinion. This is George Sutherland. He says, quote, "The federal and state courts have held that the words white person, quote unquote, were meant to indicate a person of what is popularly known as the Caucasian race." Okay, let's stop there. When they refer to the federal and state courts, that means the lower courts below the Supreme Court. But notice here that what the Supreme Court Justice Sutherland is saying, that, yeah, in the lower courts, they did base it on, this common sense understanding, right? In fact, he uses the terms popularly known. Okay, so you could translate that as common knowledge, right? Popularly known or common knowledge. So continuing here, he says, the appellant, that is to say, Ozawa, in the case now under consideration, however, is clearly of a race which is not Caucasian and therefore belongs entirely outside the zone. On the negative side, these decisions are sustained by numerous scientific authorities. We hold these decisions are right and so hold. We think these decisions are right and so hold. So, I have bolded scientific authorities here because they came to the conclusion that he is not Caucasian based on scientific authority. Okay. And they're denying what some courts have said about the definition of white persons based on what we called common knowledge and what he called what is popularly known as the Caucasian race. Okay, so Ozawa, just to repeat, based his claim on phenotypic literalism. The court rejects that. Why or how? Based on scientific authority. Okay, so let's move to the next court case here of another Asian that reaches the Supreme Court the very next year in 1923. All right, so here's another Asian. He is specifically Punjabi, which is part of North India, so therefore he's South Asian. And just like Ozawa, he is trying to claim citizenship through naturalization by claiming he's white. Now, he must have felt emboldened, by the way, because the Supreme Court just the previous year rejected Ozawa by appealing to science. But Thind, Bhagat Thind, is going to base his claim to naturalization, the right of naturalization, on science. Okay? So Thind was aware that anthropologists categorize South Asians from India as, quote, Caucasian. How is this the case? Well, there was this particular theory called Indo-European languages. And if you look at this map here, the central part is Ukraine, which is, very white and even blonde hair and other features. But the theory of Indo-European languages is that these people originating in this area, and this is the Caucasus range, the mountain range, hence the term Caucasian, all right? Around this area where the Caucasus mountain range is found, well, you see this white-skinned people that eventually migrated to other parts of the world. Certainly they went west and south to Anatolia, which is Greece today, the Balkans, and even towards Western Europe and reaching England. But they also migrated to Central Asia and even the very northern parts of India, and not to mention what we call the Middle East today and Iran and so forth. So according to the Indo-European theory of languages, all these people are Caucasian, okay, because linguistically they originate from this area. And indeed, as I mentioned previously, This is where you get the term Aryan from. The Nazi regime appropriated, or perhaps misappropriated is the more accurate term, the term Aryan to describe, the white race. Well, it originated from India. And if you know anything about India, right, they're hardly, the typical person at least, are hardly white. They're more darker skinned. And by the way, this is why the Nazis also appropriated the swastika. The swastika is actually a Hindu and Buddhist symbol, religious symbol, that's found in India. So here is the Aryan race, right, in the 1930s or 40s, actually using the Indo-European language framework for their racial concepts and metaphysics. Okay, so going back to Bhagat Singh, he is claiming he is Caucasian due to the fact that, Punjabis are part of that Indo-European group. Okay, so, and by the way, that had wide currency at the time in the 1920s in terms of, a scientific theory. So it reaches the Supreme Court, and guess what? And this is, let me remind you, 1 year after the Zava case, the Supreme Court rejects Thind. And on what basis? Well, they rejected it on, as you can guess, popular knowledge or common knowledge. Okay, in fact, here's one quote. Sutherland says, quote, Caucasian is at best a conventional term. Right? Conventional term, meaning a popular term, which an altogether fortuitous origin, is at best a conventional term with an altogether fortuitous origin, which under scientific manipulation has come to include far more than an unscientific mind suspects. So he's saying there's this degree of scientific manipulation that has happened with the term Caucasian, right? Which led to this, if you will, this wide net that was cast from their perspective to groups that weren't really Caucasian, weren't really white. All right. So here he's rejecting science and scientific theory, and he's doing it on the basis that it's not common sense. It's not common knowledge. Okay, here's another quote that I'm going to read to you from the same guy, Sutherland. Quote, it may be true that the blonde Scandinavian and brown Hindu, which is, Indian, have a common ancestor in the dim reaches of antiquity. But the average man, and let me bold that or underscore that, the average man knows perfectly well that there are unmistakable and profound differences between them today. Okay, so that should alert you to the fact that they are appealing to common sense when they invoke the so-called average man as knowing the difference between a person who is Indian and a person who is Caucasian. So forget about that science that defines Caucasian as all these different people. We're going to throw that out the window and just go with what the average man knows perfectly well. Okay? So, interesting case here with the Supreme Court just flip-flops basically on their legal rationale. And let me remind you, what could be the cause of this? Well, it's the high point of nativism. To use our earlier term, they are protecting the racial borders of the United States. In this case, they're using citizenship laws to prevent people who are not Caucasian or white from gaining citizenship.